founder of the Beckett Fund for Religious Liberty, with which many of you are familiar and with whom Notre Dame has partnered in a number of instances. Again, just a real hero for religious liberty. And selfishly, I have to say, Seamus Hasson was the first person 29 years ago who ever suggested to me, hey, Rick, you should think about trying to become a law professor at Notre Dame. And he obviously had a line in with the powers that be that make decisions about vocations, because that's been the great blessing of my life. And I also want to highlight the presence here of Mary Hasson, who is Seamus's better half, and she is the Kate O'Byrne Fellow in Catholic Studies at the Ethics and Public Policy Center in Washington, D.C. She also directs the Catholic Women's Forum, which is a network of Catholic professional women and scholars who are really seeking to amplify the voice of Catholic women in support of authentic freedom and the Church's social teaching. Well, nobody comes to these things to hear the introduction, so I'm sorry I'm taking so long. Let me say a few things about our guest, Judge William Pryor. I spent a lot of time researching this, which is to say I asked ChatGPT to give me an answer. And I was asking for something bad about Judge Pryor. And nothing's coming up. I did unearth, though, that he's a fan of Alabama football. Please don't leave. Judge Pryor was born in Mobile, Alabama, so we can give him a pass, I suppose. He got his law degree at Tulane, and he clerked for a famous federal judge with the coolest name a judge could ever have, named John Minor Wisdom of the United States Court of Appeals for the Fifth Circuit. He practiced regular law for a while, longer than most of your professors have. And then he eventually became the Attorney General down in Alabama. And at the time, I believe you were the youngest Attorney General in the country. But wise beyond his years, he did a great job down there. And he was appointed to the 11th Circuit in 2004 and eventually became the Chief Judge. He's taught at a bunch of law schools. He's been a very astute commentator on a number of legal questions. I remember him speaking here at Notre Dame, I want to say 20-something years ago, about a famous and unpleasant incident down in Alabama when future Supreme Court Justice Hugo Black defended a Klansman who murdered a Catholic priest. You can ask him about that in the Q&A. But for now, please join me in welcoming Judge Pryor.
Good afternoon, and thank you for that warm welcome and kind introduction. Thank you most of all for inviting me to deliver this lecture, which honors the Rice-Hasson family and their deep ties to this university. As champions of religious liberty and the gospel of life, their family has honored the model of the first Christian to whom this university is dedicated, Our Lady, who told the angel Gabriel, "May it be done to me according to your word." May this lecture series continue to honor her and glorify her son. Nearly 20 years ago, I delivered a lecture at Notre Dame at the invitation of the Student Government Association, in which I explored how religious faith properly informs a Catholic judge. Today, I want to return to the subject of what properly motivates a judge to perform his duty. And in so doing, I want to refute a contemporary misconception about the judicial role. Why return to this subject? The answer comes from the constant need to challenge a familiar and insidious modern refrain, indeed, the benchmark of our secular culture, the so-called judgment of history. Time and again, elites in the news media, politics, academia, and the legal culture say that what matters for anyone in public life, indeed the only thing that matters in the end, is how history will judge us. Sometimes even judges express this view, as I witnessed several years ago. This refrain is especially common now as legal commentators hyperventilate about the role of the Supreme Court and other federal courts in the politics of the moment. Critics frequently ask the rhetorical question, How will history judge the judges? We hear this refrain even from defenders of the judiciary. To take just one example, in June, a columnist for the New York Times, David French, sought to explain why federal judges appointed by the president regularly exercise independence by ruling against his administration. French is a lawyer who for years admirably represented clients in the cause of religious liberty. But what he wrote confounded me. He first explained his bona fides, that he comes from the conservative legal movement. He assured his readers that he has, quote, friends throughout the conservative legal movement, including many Trump-appointed judges, end quote. As a result, he wrote that he thinks he knows the answer, or at least part of it, that federal judges have different core motivations from elected officials. He invited readers, think of it as the difference between seeking the judgment of history over the judgment of the electorate, and to the extent that you seek approval, you place a higher priority on the respect of your peers than on the applause of the crowd. To be sure, judges should avoid, as French put it, seeking the applause of the crowd. He correctly explained many parts of the Constitution are intentionally counter-majoritarian. They're designed to protect both individual rights and our Republican form of government from majoritarian mobs. And to be fair, French knew that his column would be read by the many secular subscribers to the New York Times. But keep in mind, too, that there often is more than one crowd to please in any legal controversy. Does ignoring the applause of the crowd mean that we should be measuring our life's work according to the so-called judgment of history? Or is the judgment of history instead a shorthand way of referring to the applause of another crowd, an elite one and a smaller one, but a crowd nonetheless? Should a judge think about the applause of any crowd, including even a crowd of historians? Should a judge think about the approval of peers, especially when even elite peers are fragmented in our legal culture? Which peers? Should a judge in New England or California seek the approval of his peers in Boston or San Francisco? Should a judge in Texas, Florida, or Alabama seek the approval of his peers in Waco, or Tampa, or Tuscaloosa? Admittedly, several judges think that the judgment of history matters a lot. For example, 20 years ago, a federal district judge in Massachusetts, William Young, wrote an opinion about the decline of the civil jury trial and predicted history will not look kindly on that generation of jurists who acquiesced in the eclipse of our greatest bulwark of personal liberty, the American jury. 5 years ago, another district judge, Josephine Staten, sitting by designation on the Ninth Circuit, dissented from the dismissal for lack of standing of an ambitious lawsuit about climate change. She wrote, "If plaintiffs' fears backed by the government's own studies prove true, history will not judge us kindly." Justice Sotomayor used similar language when reading her dissent in Trump versus Hawaii from the bench. History will not look kindly upon the court's misguided decision today, though that line did not appear in her written opinion. When Judge Judith Kaye of the New York Court of Appeals dissented from a decision that the state constitution did not provide a right to same-sex marriage, she predicted that, quote, future generations will look back at today's decision as an unfortunate misstep. And when Justice Marilyn Kelly of the Michigan Supreme Court dissented from a decision upholding a voter identification law, she wrote that history will judge us harshly for that ruling. This kind of rhetoric in a judicial opinion once prompted me to respond to it in a concurring opinion. 5 years ago, our court, in an en banc proceeding, ruled that Florida did not violate the 14th and 24th Amendments to the Constitution when it required convicted felons to pay all fines, court costs, and restitution before restoring their voting rights, even after the felons had completed their prison sentences. The main dissenting opinion ended by reminding readers that our predecessor circuit, the old Fifth Circuit, quote, had been rightly praised for its landmark decisions on voting rights in the 1950s and 1960s. But the dissent expressed doubt that the majority's decision would be viewed as kindly by history. That smug charge raised my hackles. As a former law clerk to one of the heroes of the old Fifth Circuit, Judge John Minor Wisdom, I viewed the dissent as misrepresenting the example set by our predecessors. Judge Wisdom and other judges like Elbert Tuttle, Richard Reeves, and John Brown courageously upheld the rights of black voters because the Constitution ratified by the American people required them to do so, not because they were concerned about the judgment of history. My concurring opinion responded that the heroism that the Constitution demands of judges, modeled so well by our predecessors, is that of devotion to the rule of law and basic morality. As I saw it, our duty is not to reach the outcomes we think will please whoever comes to sit on the court of human history. The Constitution instead tasks us with administering the rule of law in courts of limited jurisdiction, which means that we must respect the political decisions made by the people of Florida and their officials within the bounds of the supreme law, regardless of whether we agree with those decisions. And in the end, as our judicial oath acknowledges, we will answer for our work to the judge who sits outside of human history. The irony about the modern obsession with what our culture calls the judgment of history is that history itself tells us that previous generations thought that the measure of a judge's duty is not history, but instead the oath of office that he swears before beginning that duty. Before taking office, a federal judge must swear to administer justice without respect to persons and do equal right to the poor and to the rich, to faithfully and impartially discharge and perform all duties under the Constitution and laws of the United States, and to support and defend the Constitution of the United States, so help me God. Taking that oath empowers the appointed judge to begin his duty. We hold formal ceremonies when public officials take oaths of office. Witnesses place a hand on the Holy Bible when swearing an oath. So do public officials, ranging from the mayor of a small town to the President of the United States. Jurors take an oath collectively administered by a court official at the start of any trial. Grand jurors do the same before starting their proceedings. Lawyers take an oath for admission to the bar. And judges take an oath administered by another judge before being invested in a courtroom with a robe that serves as a symbol of the office. Despite the solemnity of these ceremonies, one might wonder whether we still take oaths seriously. When someone asks why judges perform their duties impartially and independently, should we not consider their oath as the simple answer? If judges reach decisions that we think are wrong, why do we not say that they have betrayed their oath? Why appeal to the so-called judgment of history? Consider what history tells us about an oath. Ancient generations considered oaths to be essential tools of accountability. An Anglican minister wrote in the 19th century that oaths have persisted through all the diversified stages of society, from the lowest barbarism to the highest cultivation of civilized life. Even primitive oaths rested on a notion of a divine or supernatural power taking cognizance of and in some degree regulating the affairs of mankind. The Code of Hammurabi employed an oath for a woman to rebut a false accusation of adultery before she could return to her husband. Ancient oaths became required of signatories of treaties and of government officials, judges and jurors, and particularly by the Romans, of soldiers. Plato explained that a judge's duty is not to make a present of justice, but to give judgment, and he has sworn that he will judge according to the laws and not according to his own good pleasure. The Roman Emperor Justinian recounted how judges in his day and in former times could not accept the judicial office unless they had previously made an oath that they would on all occasions decide according to the truth and in compliance with law. The ancients also marked the taking of an oath with ceremony. Greeks and Romans took oaths approaching the altar of a particular god, laying the hand upon it and swearing by the divinity to whose honor it was raised. Scripture teaches the same lesson about the importance of an oath. The book of Genesis tells us that Abraham, with raised hand, swore to the Lord, God Most High, creator of heaven and earth, told the king of Sodom that he would accept nothing belonging to him. In Deuteronomy, God commanded the Israelites, "You shall fear the Lord your God and serve him, and shall take oaths in his name." Even God took an oath when he allowed Ezekiel to prophesy to the people that he swears with uplifted hand that the nations around them will also suffer scorn. The New Testament repeats this lesson about the gravity of oaths. The author of the Epistle to the Hebrews wrote that men swear by someone greater than themselves, and the oath confirms what is said and puts an end to all argument. St. Paul, too, invoked God as his witness in his epistles to the Corinthians and Romans. In St. Matthew's Gospel, Jesus taught, "Again, you have heard that it was said to your ancestors, 'Do not take a false oath, but make good to the Lord all that you vow.' But I say to you, do not swear at all, not by heaven, for it is God's throne, nor by earth, for it is his footstool, nor by Jerusalem, for it is the city of the great King. Do not swear by your head, for you cannot make a single hair white or black. Let your yes mean yes, and your no mean no. Anything more is from the evil one." The early preeminent theologians understood Jesus to mean not that an oath was forbidden, but that an oath should be reserved for extraordinary occasions. St. Augustine wrote that Jesus' admonition meant that a Christian should refrain as far as he can from indulging in an oath unless by necessity, when he sees men slow to believe what is useful for them to believe. St. Thomas Aquinas agreed in the Summa when he wrote, "Wherefore an oath is not to be reckoned among those things that are desirable for their own sake, but among those that are necessary for his life." The Church settled this teaching at Trent by instructing in the Catechism, although oaths are in themselves good, their frequent use is by no means praiseworthy. That history informed our Anglo-American legal tradition of taking oaths on assuming office. Beginning in the 10th century, English monarchs swore a coronation oath. After the Glorious Revolution, that oath required the king to govern according to the statutes in Parliament agreed on and the laws and customs of the same. And that tradition of oath-taking crossed over to colonial America. During the Revolutionary era, state constitution required oaths of office, often with religious requirements. South Carolina required anyone appointed to any office or to any place of trust before entering upon the execution of office to take an oath swearing to support, maintain, and defend the Constitution of South Carolina, so help me God. Vermont required its officers to swear by the ever-living God or affirm in his presence in the presence of the Almighty God their allegiance and intent faithfully to execute their offices according to law. Delaware required its officers to swear or affirm that they will bear true allegiance to the Delaware state and submit to its constitution and laws, and that they profess faith in the Trinity and divine inspiration of Holy Writ. Pennsylvania required both allegiance and for its officers to swear or affirm that they will faithfully execute the office according to law. The Constitutional Convention prompted a debate about the necessity of oaths. Noah Webster argued that all test laws and oaths of allegiance should be purged from American law. He suggested, like James Wilson, that oaths were necessary to rivet the chains of feudal vassals. For a government based on popular sovereignty, they saw no need for an oath. But Webster and Wilson were outliers among the founders in this regard. Joseph Story stated the majority view when he described the necessity of oaths as a proposition too clear to render any reasoning necessary in support of it. He explained oaths have a solemn obligation upon the minds of all reflecting men, and especially upon those who feel a deep sense of accountability to a supreme being. The Constitution maintained the tradition of official oaths. Article 2 prescribed a specific test for the presidential oath that requires him to preserve, protect, and defend the Constitution. Article 1, Section 3 required senators sitting for trials of impeachment to do so on oath or affirmation. And Article 6 required all federal and state legislators, executive officers, and judges to be bound by oath or affirmation to support this Constitution, but it banned any religious test. During the ratification process, some Americans objected to the ban of religious tests, as some Protestants feared the election or appointment of Catholics to federal office. James Iredell, a delegate to the North Carolina Convention, provided my favorite rejoinder to these objections when he rose to defend the ban on religious tests. His words were especially memorable for Catholics. Iredell said, "I met by accident with a pamphlet this morning in which the author states there's a very serious danger that the Pope of Rome might be elected president. I confess this never struck me before. And if the author had read all the qualifications of a president, perhaps his fears might have been quieted. No man but a native and who has resided 14 years in America can be chosen president. I know not all the qualifications for a pope, but I believe he must be taken from the College of Cardinals, and probably there are many previous steps necessary before he arrives at this dignity. A native of America must have very singular good fortune, who, after residing 14 years in his own country, should go to Europe, enter into Romish orders, obtain the promotion of cardinal, and afterwards that of pope, and be at length so much in the confidence of his own country as to be elected president. It would still be more extraordinary if he should give up his popedom for our presidency." Now, we often marvel at the foresight and wisdom of the founders. Add to the list their prescient insights that in 1787, James Iredell foresaw the election of Pope Leo XIV. And we can be grateful that, as Iredell also foresaw, Pope Leo prefers serving as the vicar of Christ instead of running for a 4-year term as president. But I think all of us here can agree Pope Leo would undoubtedly make a fine president. The framers' general understanding was that prescribing religious tests did not necessarily remove the religious significance of the general oath. James Madison, for example, explained in a letter to Edmund Pendleton in 1787 that an oath should make a religious test unnecessary. Madison wrote, "Is not a religious test, as far as it is necessary or would operate, involved in the oath itself. If the person swearing believes in the Supreme Being who is invoked and in the penal consequences of offending him, either in this or a future world or both, he will be under the same restraint from perjury as if he had previously subscribed a test requiring this belief. If the person in question be an unbeliever in these points and would, notwithstanding, take the oath, a previous test could have no effect. He would subscribe it as he would take the oath without any principle that could be affected by either. Madison's argument was that a religious believer would take an oath seriously without need of a religious test, and that a religious test could be declared by an unprincipled atheist without fear of punishment after death. Either way, a religious test was unnecessary. But the oath itself still mattered in early America. Throughout the 19th century, American leaders described their oath of office as the standard for their public duty. Chief Justice John Marshall's opinion in Marbury versus Madison referred to the oath as authority for judicial review when he described the judge's obligation to adhere to the Constitution as a rule for his government and suggested that a contrary reading would make taking his oath a crime. President Andrew Jackson defended his veto of the legislation for the Second Bank of the United States by appealing to his oath when he wrote, "Each public officer who takes an oath to support the Constitution swears that he will support it as he understands it and not as it is understood by others." And President Abraham Lincoln defended his decision to issue the Emancipation Proclamation by arguing that it is his oath to preserve the Constitution imposed upon him the duty of preserving by every indispensable means that government, that nation, of which that Constitution was the organic law. After the Civil War, consistent with Lincoln's view, Section 3 of the 14th Amendment barred insurrectionists who had, quote, previously taken an oath of office from holding several federal and state offices unless Congress removed that disability by a vote of 2/3 of each house. Today, judges still take the same oath that Chief Justice Marshall swore. Judges swear before God to uphold the Constitution and laws of the United States wherever it leads. We do not swear to follow a prediction or speculation about what future generations will favor. When modern society substitutes the so-called judgment of history for the historical standard of the oath of office, it raises almost unanswerable questions. How will history judge any public official? And how often will any public official's work matter to any legal historian? If we consider the current universe of federal judges, keep in mind that it comprises more than 1,000 judges on the inferior courts. It includes 677 positions for active district judges for the 94 districts in the United States and its territories. Approximately 400 senior district judges also perform duties in a semi-retired status for those courts. There are 179 positions for active federal circuit judges on the 13 circuit courts of appeal, and approximately 100 senior circuit judges who perform duties for those courts. Not many of those judges will ever be studied by a legal historian. Visit any federal courthouse in the United States and ask a clerk, other official, or lawyer how much they can tell you about any deceased judge whose portrait adorns a wall in the courthouse, especially when that judge has been deceased for more than 20 years. Then ask how history judged his work. Be prepared for a blank stare. Consider, too, the volume of the caseload in the federal courts. Over the course of a judicial career, a federal judge will participate in tens of thousands of decisions in thousands of cases. The vast majority of those decisions will be routine, perhaps even mundane. Will historians care about a claimant's application for Social Security benefits, a consumer's petition for bankruptcy relief, a drug trafficker's criminal sentence, or an employee's complaint for unpaid wages? Contemporary elites might argue that in important cases, history will remember a judge's work, but that argument has troubling implications. An applicant for Social Security benefits, petitioner for bankruptcy leave, criminal defendant, or underpaid employee might argue that his case is the most important issue in his life. Surely we should not employ a different standard for the judge's work in their cases, even if history will soon forget them. The same standard, the oath to do equal right to the poor and to the rich, based on the rule of law, must govern all cases. When someone argues that the so-called judgment of history matters in some case, he betrays his desired result in a high-profile controversy, regardless of what the judge's oath to uphold the law requires. But asking how future generations will view us is a fool's errand. The person who asks that question is only projecting his hope about what future generations will think. Yet no one knows whether future generations will be wise or wicked, nor do we know whether they will be any less divided in their views than previous generations have been. The most abominable opinions in the history of the Supreme Court were written by jurists who likely thought they stood on the right side of history. Roger Taney likely thought so when he penned Dred Scott. Yet his notorious opinion helped lead to the Civil War. Oliver Wendell Holmes undoubtedly thought he was on the right side of history when he wrote 3 generations of imbeciles are enough in Buck versus Bell. But Americans, thankfully, have since abandoned state-enforced eugenics. Harry Blackmun probably thought history would look kindly on his opinion in Roe versus Wade. A half-century later, the Supreme Court overruled it as an egregious mistake. And in each period, the jurist peers celebrated those opinions. In 2014, Robert George, the great professor of jurisprudence at Princeton University, explained the modern obsession with the so-called judgment of history. Speaking at the National Catholic Prayer Breakfast, he said, "They warn us that we are on the wrong side of history. They insist that we will be judged by future generations the way we today judge those who championed racial injustice in the Jim Crow South." Professor George then explained, but history does not have sides. It is an impersonal and contingent sequence of events that are determined in decisive ways by human deliberation, judgment, choice, and action. Nor is history or future generations a judge invested with godlike powers to decide, much less dictate, who is right and who is wrong. He explained that elites appeal to the judgment of history because they lack faith. The idea of a judgment of history is secularism's vain, meaningless, hopeless, and pathetic attempt to devise a substitute for what the great Abrahamic traditions of faith know is the final judgment of Almighty God. History is not God. God is God. History is not our judge. God is our judge. He contrasted the pathetic substitute of secularism with the moral truth. One day we will give an account of all we have done and failed to do. Let no one suppose that we will make this accounting to some impersonal sequence of events possessing no more power to judge than a golden calf or a carved and painted totem pole. It is before God, the God of truth, the Lord of history, that we will stand. And as we tremble in his presence, it will be no use for any of us to claim that we did everything in our power to put ourselves on the right side of history. For a judge who has sworn an oath, the trembling might be even more visible. As the Catechism of the Catholic Church explains, taking an oath or swearing is to take God as witness to what one affirms. It is to invoke the divine truthfulness as one's own truthfulness. An oath engages the Lord's name. And so, a false oath is a violation of the commandment not to take the Lord's name in vain. Recall that the prayer, "So help me God," is a shorthand way of asking for his assistance on Judgment Day so long as the declarant speaks the truth. St. Thomas More, the patron saint of lawyers and judges, provides the right role model for public duty. Remember that St. Thomas More was executed because he refused to take a false oath. He refused to swear to the supremacy of the king over the church. And as he explained, a moment before his execution, he died the king's good servant and God's first. St. Thomas More understood that an oath has eternal consequences. His elite contemporaries, in contrast, thought that they stood on the right side of the king and of English history. As Hilaire Belloc once put it, Thomas More's peers thought he was a crank. But St. Thomas More understood that Christians are called to be what St. Paul described as fools for Christ. Jesus said, if anyone comes to me without hating his father and mother, wife and children, brothers and sisters, and even his own life, he cannot be my disciple. So my oath, with God as witness, to uphold the rule of law must matter more than the judgment of any peer or historian. Thank you, and may God bless you.
Thank you all. So think of some questions, and those of you who are law students, I'm going to cold call you in a little bit. But I wanted to ask the first question, Judge, and obviously feel free to say I'm a judge, I can't answer that. What circumstances could ever arise where your oath would require you to not follow the positive law that's in front of you?
This was actually the topic of that lecture in 2008 that I gave at the Student Government Association. Happily, this has not happened to me. In the American experience, the possibility of there really arising a conflict between your moral and legal duty, I think, is a remote one. I think it's more likely to be a fraught question if, say, you're a trial judge in a jurisdiction where you're charged with deciding whether to give a minor permission to obtain an abortion, or whether you're the trial judge responsible for sentencing a defendant to death. Those kinds of questions are happily above my pay grade. I'm just a mere appellate judge. And my task is to figure out what the law requires and whether, for example, a death sentence has been entered in accord with the law or not. In fact, Justice Barrett, when she was young, co-wrote a law review article about this very topic and explained there's no conflict in capital cases for appellate judges. I have a funny story about that. Justice Scalia's last lecture was at the Dominican House of Studies in Washington. I was there. And he said that he would have, if he thought that the death penalty was immoral, then he would have a problem. He would have to resign. And I challenged him during Q&A and said, that's not true, and invoked then Professor Barrett's article. And I said, all you're trying to do is figuring out whether it conforms to the law or not. The decision about whether to enter the sentence of death has already been made by, say, the state government. And he said, oh, so you think I could have been a judge in Nazi Germany? And I said, no. And then I went back to explain, you're, as an appellate judge, what his role is. He says, so as an appellate judge, I'm off the hook. He said, that's a relief. The next morning, I was a member of the Sentencing Commission. I went over to our meeting, and Rachel Barco, who had clerked for Justice Scalia, I told her this story, and she said, this is the story of my clerkship. She said, I would challenge him, and then he would attack and pounce, and then when I would hold my ground and show that I was right, then he would laugh it off. What I explained, though, also in that lecture is that this really raises the question of material cooperation with evil and proximate material cooperation with evil, and a Catholic can understand that, for example, a mail carrier, a postman, can deliver life-saving medication, holy Bibles, while still respecting the rules of prompt delivery and privacy when delivering pornography. That doesn't make the mail carrier's work immoral. or approximately, cooperating materially in approximate way with evil. And so it is for a judge. If I really thought that that kind of conflict would arise, I would have to resign my office before violating my oath. I don't think you can substitute, after taking that oath, your moral judgment for the law.
Thank you. Questions? Yes, sir.
How would Your Honor respond to Professor Adrian Vermeule's view that judges should go beyond merely stating what the law is to what the law should be? What are your thoughts generally on Professor Vermeule's common good constitution?
Well, if you Google against living common goodism and put my name, up will come a PDF of my complete response to Adrian Vermeule and why I think he's wrong. Look, there was a time in our country where judges and lawyers would appeal to principles of natural law and natural justice. By the way, for us Catholics, they were doing it with respect to a very Scottish Protestant Enlightenment perspective of natural law. And I think that actually their perspective about that is something we have to be aware of and study if we're going to understand the original meaning of, say, the freedom of speech or the right to bear arms, which they understood to be natural rights. I think we have to understand that. But the idea that we can just supply natural justice or our view of natural justice to contradict or bend the meaning of a written constitution we've sworn to uphold, I reject that. And this is something that following the founding period, American judges and lawyers figured out. The Constitution calls itself the supreme law of the land. That means something. That means that we have to respect it as the supreme law and not something else that we would use to override it.
But, Judge, nothing in your response to the question or in your piece responding to Professor Vermeule is in tension with saying, like, hey, those of you who are legislators.
Oh, of course. That's who has responsibility for ensuring the common good, the legislature. But that's not the role that is given to judges.
Thank you, Judge. It seems like there's two ways to read the statement supreme law of the land. One is that when there's other law in contradiction with the Constitution trumps. And the other is that it's the kind of font of all law and the source of all law. It seems like with the first one can still have extra textual rights that one can appeal to and that can be binding on the government, even if it's not present in the Constitution, whereas only the second meaning seems to cut against a natural law, like an extra textual natural law. How would you respond to that?
Well, I'm not sure if I understand your question. If you're saying extra textual rights, of course there are extra textual rights. The Ninth Amendment mentions the fact that there can be other rights retained by the people. That doesn't mean they're constitutional rights. But it does tell us something about how we're to understand and interpret the powers that are granted by the written Constitution. But when the Supremacy Clause declares the Constitution the supreme law, it refers to this Constitution as the supreme law. It's referring to a specific written text as the supreme law, not to something else.
But it's not making a claim, is it, the Supremacy Clause, that is about the sort of the moral legitimacy of this Constitution?
No.
That doesn't supply itself.
No. But if you don't think that it's a moral Constitution, you certainly shouldn't take an oath to uphold it and to support and defend it. I think every judge or every official who takes that oath has satisfied themselves that they can do so as a moral matter. I hope you have. You shouldn't take the oath if you haven't.
Yeah, in the back, Dave.
Thank you, Judge. I wanted to follow up on just the last thing that you said there. To take the oath in the first place, you have to make a certain substantive moral judgment that the Constitution or the system that we have is sufficiently good in order to justify being bound by it.
Yes.
And so maybe that helps resolve some of the tension of not being too caught up in sort of the contingent norms of the present age, the present generation. But even that initial moral judgment that this Constitution is good, or at least good enough, is itself a product of sort of contingent historical moral judgment. So how do we wrestle with that tension at sort of step one?
Well, I mean, you have to read the Constitution. I mean, the Constitution it is a written text. Everything about it was reduced to writing. You have to understand it in the backdrop of the common law and the law of nations and everything that led to it to make sure that you're understanding it properly. But I mean, I think you satisfy it by reading it to see if that's something that you can swear or affirm to uphold, to defend.
Father Pat, you give your nihil obstat to that?
No comment.
Thanks for the vote of confidence, Father.
Get over here.
Yeah, thanks so much for your talk. Stepping back from the American context, going back to your citations to the gospel and to Augustine Aquinas, you said the words like "let your yes mean yes, your no mean no." You kind of do the science exposition from the two saints about how oaths are still permissible as a kind of exceptional places in order to kind of serve this role of social utility, kind of as a guarantee that I really mean this. You have to mean it anyway. We don't.
Well, for particularly important matters too.
Yeah, particularly important matters, I guess. Particularly because it serves like a social utility. And I'm not making this argument, but how do you respond to somebody who says where oaths no longer really carry this weight of connecting my word, like an acknowledgement of the divine word? If it's really, oaths are really in the Christian tradition about kind of this communication to a social context. Just like to society that I really mean this. Not really, they're not actually binding you in a special way. You're always bound by your word. Right? If you said a Christian who said, I will uphold the Constitution, they're still bound by that. They don't have to put their hand on the Bible to be bound by that. But they put the hand on the Bible in the Christian tradition in order to kind of communicate the special importance and this acknowledgement of the divine judgment.
Well, and to take God as your witness.
Yeah.
You're invoking God.
Have God your witness anyway, but you're particularly doing it externally in order to kind of communicate the high purpose. But if society no longer actually takes that seriously, what role do you serve?
Well, here's the thing. Maybe elites don't take it seriously. I think society does. I mean, when you go to the administration of an oath to a jury in a courtroom in America, I think jurors take that seriously. I think when witnesses put their hand on the Bible in courtrooms, I think they take that oath seriously. And I think there are a lot of public officials who, when they put their hand on the Bible and take an oath, they take it very seriously. And I think, frankly, that we focus so much on what divides judges in our country. And those are the most interesting cases, the one that divide judges. And you spend a lot of time in your law school classes studying those kinds of cases where there are good arguments on both sides. But when you go to, many of you are going to go clerk for judges. One of the things you're going to learn quickly is how often judges agree. How few dissents there are, particularly in the circuit courts of appeals. We have panels of 3 judges where judges were appointed by different presidents, and they agree about what the law requires. I would argue that one of the reasons they do is so many of them take the oath seriously. And it's been a successful experiment in law. Yes?
Tia.
Advice for people who are looking to be attorneys in a place that potentially has constitutional provisions that are antithetical to our rules. So, for example, the California Constitution has a right to a warden to resign in its Constitution.
Right.
Is that a point where, as somebody who wants to work in California, chooses to be a senator or a member of the legislature,
Yeah.
you have to take that oath?
Yeah.
But the way to change that situation is to
Well, I'm going to return to something that Justice Scalia said in that lecture I was talking about earlier. He said he could happily do his job in a regime that really did preserve a right to abortion, because what he's doing is he's saying that law does not empower me to interfere with that decision. That does not mean that I endorse that decision. If the government decides not to interfere in that decision. Now, President Lincoln, of course, rejected Dred Scott and worked hard to overturn it. And where he had the opportunity to do something that didn't really conform to the strict reading of Dred Scott, issuing a patent to a black inventor, for example, he did so because although he respected the judgment in Dred Scott as between those parties, he was going to work to overturn it. He was going to work to supply a different rule. And of course, we ultimately amended the Constitution to supply a different rule. So I don't think there's really anything about that kind of regime that necessarily prevents you from doing what Lincoln did as president, for working for a moral result. It might be that you'll be confronted with a situation where the law doesn't empower you to do something that you think is what morality requires, but it doesn't mean that you've done anything immoral by doing your duty.
Professor Audi.
Thank you. I much enjoyed that, and I want to pursue the question this man raised by asking about a possibility that I imagine is under discussion in some quarters. Many, I suppose, take the oath, though they are not theists.
Yeah.
And they are respectful of tradition.
Yes.
And think that they are not affirming anything religious in taking the oath.
Yes.
What would you think about offering secular oaths that express the same content so that one can express the same level of commitment? There probably are people who would appreciate the opportunity, and this need not be considered to be anti-religious.
Oh, absolutely. Well, our oath really is a secular oath because it's not an oath. I think a religious person will take religious significance from taking what is really our secular oath. It's true that the statutory oath has "so help me God," but there are plenty of judges who don't read that last part. They don't read that. And the rest, so it is, but it is a secular oath.
I think there are people who would think that isn't really secular, but they think it isn't something that really gives them a commitment to anything theological, but they don't like participating in that way and don't want to make a fuss. Should we, as a concession, just allow an alternative oath? Maybe you put in words like,
well, what about what?
Deeply believe in morally and in terms of the Constitution's commitment.
I guess I'm puzzled by what you think, if you take out the word "so help me God," what you think makes it anything other than a secular oath. The religious test was banned by the Constitution. Why isn't swearing to uphold the law anything but secular?
I agree with you on that. I just think "so help me God," though it isn't.
Yeah, well, you don't have to say that.
Will make some people feel uncomfortable, but they live with that. And I'm not really suggesting this as a proposal, but I'd like to have a theory of why we just shouldn't go there.
Why we shouldn't go there?
Should not, right? I'd rather think we should not. That's my own personal view.
Yeah, well, lots of people agree, lots of public officials agree with you and don't read that when they take the oath.
I see, so they really opt out.
That was my point, yes, that's what I said. There are plenty of judges and other public officials who don't, and for that matter, witnesses and jurors who don't say the "so help me God" part. That's not a violation.
Other question? Yeah, in the back.
You know, we get that because George Washington added it to the presidential oath. It's not in the text of the Constitution.
So the scripture talks a lot about the dangers of taking an oath in the first place, and I think the reason that is because that implies that taking an oath, there are provision under which you are actually obligated to violate it.
Yeah,
right?
yeah,
You see that,
right.
Christ says, do not swear by heaven or honor, because, you may have situations where you have to violate that. We see that in the Old Testament,
Yeah.
right? Where the king wasn't supposed to sacrifice his daughter, even though he swore to.
Yeah. Yeah, the fact, though, is that we recognize that, how many of you are not sinners? All right, we've all, how many have never told a lie? Right? I mean, the idea was that by taking a public oath with ceremony, that where people can witness what you're swearing, that you might take it a little bit more seriously than some other things that you say in ordinary life where you fib.
Yeah, but I'm not implying that, like, it's bad if you violate the oath per se. I'm saying, I think you would be held liable for your conduct under the oath, even if you're performing it in service of some duty, in service of something that you swore to. You are still held liable. Like, at least that's what the Christian scriptures do.
Yeah, yeah. Well, look, so are you telling me that I should take what Christ said as literally regardless of what the church settled at Trent?
So I'm not a Catholic.
Well, I am. I am, and I'm going to take Trent.
Before we go all like heavy metal counter-reformation here, I want to ask a question, Judge, about this judgment of history point. So when you set up this choice, right, either follow the law as you've taken an oath to do, or submit yourself anticipatorily to the judgment of history, you're presuming, I think, a certain theory of constitutional interpretation. That is, you're assuming that there is something called the law, the meaning of which is fixed, apart from what future generations do think, have thought, or we speculate might think. I wonder, does your dilemma, oath or judgment of history, disappear if you have the kind of theory of constitutional interpretation where precisely what it means to follow the law is to make the Constitution as good as it can possibly be?
Well, I think there would still be a problem with appealing to the so-called judgment of history because of what I said earlier, which is we don't know what future generations will think, and that's a fool's errand. If that's your conception, and you're right, my conception of the oath is very much driven by my perspective that the law is objective, that it is knowable, that there are right and wrong answers to the questions that come before the courts. It's not always easy. We don't always get it right. But the entire premise of the oath, from my perspective, is that it is objective and knowable. If you have more the living constitutionalist perspective, I think you would still be obliged to apply the law as you think it will best serve the country and Constitution now, as opposed to what future generations will think about it, which is, again, I want to ask many of the people who ask that question or suggest that that's the measure, how many of them would have predicted the election of Donald Trump? Because I think a lot of people who make that appeal would not have predicted that, particularly those who think the moral arc of the universe always bends towards justice and we're always pursuing human progress, right? I'm not making a judgment about that. Look, I want to be very clear about that. I mean, look, one of the great things about being removed from politics is I don't care who wins elections anymore. I didn't even vote in the last presidential election.
But you are rooting for Pope Leo.
I am rooting for Pope Leo.
Thank you all for coming, and please join me in thanking Nick.